Okay, so welcome to this, the latest in Cornerstone's series of webinars in the public law, local government and housing context. This one, Homelessness Appeals, Top Tips for an Effective Local Authority Response. As you'll see from the slide on the screen, your presenters today are me and my friend, roommate and colleague, Andy Lane. For those of you who don't know us, we specialise in public law, local government and housing law. So what can you expect from today? Well, as many of you will know, homelessness is a multifaceted and indeed complex area of law and practice. There are, in any case, numerous issues for any review officer to consider, whether that be homelessness, eligibility, priority need, intentionality, suitability, to name but a few, each of course with its own body of law. And so there is consequently considerable scope for potential error. The consequence of error or alleged error is of course the right of the applicant to appeal to the county court from any review decision by way of a statutory appeal. And those appeals, as many of you again will know, are often a time-consuming and very costly process, with costs liability in the case that the local authority loses often between 10 and 20,000 at the very least, and sometimes considerably more. So what is the key to mitigating the risks of Section 204 appeals and the time and cost related to them? Well, the short answer is an effective and efficient local authority response. So the focus of this webinar will, as the title will no doubt have given you the clue, is practical tips for local authority officers and solicitors when responding to Section 204 appeals. So with that in mind, please note that this will not be a complete or comprehensive guide to homelessness appeals. Rather, it will focus on individual and particular aspects of homelessness law and practice to enable a more effective and cost-efficient local authority response. And many of those issues will be of a practical nature as opposed to necessarily legal. On which notes, content-wise, Andy and I will cover the following key issues. So key aspects of the appeal, understanding the nature of a Section 204 appeal and the local authority's role in particular, and Andy's going to take you through those slides in a moment. I will then take you through a section which we've labelled Prevention is Better Than Cure, the importance of the Section 202 review. And in that I will look at some of the common errors that are made in review decisions. Perhaps as a little unfair to categorise it in that way, but some of the common challenges that are often made to review decisions and how to deal with them. Andy will then take a look at mitigating risk when the prevention fails, taking a look at early merits reviews and settlement options once the Section 204 appeal is in play. I will then cover how to keep the court happy with some brief practical tips before Andy finishes up by looking at how to minimise financial liabilities, the question of relief in an appeal, and costs. So without further ado, let me hand over to Andy, who, as I say, is going to take you through key aspects of the Section 204 appeal. And Andy, you're on mute.
It normally goes for about 3 slides, that, but thank you very much, Dean. As you can see, I'm still rocking the 1970s DJ look, but I'm sure I'll be able to work without headphones soon. I'm dealing, as Dean has said, with some key aspects of the appeal and really putting the appeal into context as to what we're actually dealing with here, as compared, for example, with an appeal against a possession order decision. And if we have a look at the next slide, of course, it starts, as you would expect, at the beginning. In other words, this is an appeal right which has been brought in from the beginning of 1997 to an applicant who has had an unfavourable decision on review. In other words, as we know, people have a right to review within a certain timescale, and they have a right to appeal. They don't need to seek permission. And you can see that that is clear, but also that it's on a point of law. In other words, as is said elsewhere, this is not dealing with issues of fact in large part, but points of law. There is provision, because although normally it would be a 21-day time period to bring in the appeal after the review decision, there is provision, and again we'll see an authority later on about late reasons and what good reasons for a late appeal may be. But obviously that needs to be something that's applied for, and the local authority will need to consider what their position is on that. I have to say, in many instances, the local authority may well concede the point if it's only a few days out of time and there is, on the face of it, a good reason. What we also know, of course, is that the court's powers are, as you see at subparagraph 3, fairly limited. In other words, very definite, but fairly limited in that they can obviously decide that the appeal isn't successful, thereby confirming the review decision. They can quash it, which is the normal order, if the appeal is successful, or in a small minority of cases, they may decide there's no point sending it back to the local authority and instead vary the decision in the favour of the applicant. But those are the options to the appeal court. Before moving on to the next slide, can I make it also clear that, of course, there has been recently, and Underwood and Milton Keynes Council, and indeed Stanley and Welwyn Hatfield made this clear, is that even if a review decision is late, it will be a review decision. There used to be a debate as to if there hadn't been an agreement to extend the time to make the review decision, which in most instances would be 8 weeks, it wouldn't count as a review decision. But those authorities in the Court of Appeal made it quite clear that it is late. So although you can appeal against the 184 decision if there's been no review decision, if a review decision comes on board before determination of that, that will be the decision to be appealed. And those two authorities made that clear. So that is the basis of it. And you can see there Lord Bingham really setting out the fact that this is a point of law and it is akin to judicial review. It's often something, and this is in a sense where Dean and I started in discussing the possibility of this webinar, that it's sometimes a source of frustration in making it clear to the court that, of course, it's a judicial review function. It's not what they would have done. It's not what they would have seen appropriate. It's what the local authority as the decision makers are entitled to do in public law terms. But that's a fairly wide concept, as you can see there. You can also see, incidentally, there is reference there to rationality. I have to say, the days when you used to get 8, 9, 10 grounds of appeal, and the last one saying, regardless of the above, the decision was irrational, when you used to think, well, if you can't get home on the 7 grounds, I don't think you're going to get home on the 8th, have long gone. And I think my experience is that some very good advocates and lawyers for applicants, and you tend to get much more focused and limited grounds of appeal rather than the broader rationality challenges. But it is a public law challenge, and that therefore you are looking at it through those lenses. Runa Begum itself was an Article 6 matter and confirmed that there was compliance with Article 6. They made some interesting comments, I ought to say, in that case about contracting out, but that was dealt with at a later authority, which we'll come on to. This is the scenario we've been dealing with, as I say, for the last 25 years since this was brought in January 1997. So that's the nature of the appeal. So what do we mean by a point of law? Well, you can see that what we often cite in our skeleton arguments is the Lord Justice Old comments from Runa Begum and Tower Hamlets, not only matters of legal interpretation, but also the full range of issues which would otherwise be the subject of a judicial review, such as procedural error and questions of vires, to which I add also of irrationality and inadequacy of reasons. So that's a fairly clear exposition of what's there. We'll see as at the bottom of the page, for example, in a case that Dean was involved in, which is Adesotu and Lewisham, an example of where, in fact, there was no point of law arising from a review decision because there was an attempt to challenge it on discrimination grounds. And because of the wording of the Equality Act, and Dean will know this much better than I, but because of the wording of the Equality Act, and in particular Part 9 of the Act and the enforcement criteria of sections 113 and 114, it couldn't be dealt with through the section 204 appeal. But on the other hand, Ranjit and Ricardo from these chambers were involved in James and Hartsmere, which dealt with the contracting out issues. And there was a question of whether that arose from the review decision. It's fairly obvious if you've challenging a decision as to the priority nature of the applicant, or the intentionality question, or the eligibility question, or the suitability question, or the whether they're homeless question, they're clearly arising from a review decision. But what about whether there has been legitimate contracting out to a third party of the review function, which is of course possible. Has it been done properly? And as you can see from James and Hartsmere, it made it clear there that that was a proper matter for the adjudication of the Section 204 appeal. What there isn't is a fact-finding jurisdiction. There are a few exceptions to that, but as in the large part, there is no fact-finding jurisdiction of the court. So, for example, in the Bubb case you see there and Wandsworth, the question as to whether the person received the offer letter wasn't a matter for the judge to hear evidence on, for example. That was a matter to decide whether the local authority were entitled to come to the conclusion that they had received. In other words, a classic public law approach. But it wasn't for the judge, as I say, to hear evidence as to, in order to determine for themselves whether in fact the letter had been received. And we've seen authorities such as Tomlinson and Birmingham, where the Supreme Court have rejected the proposition that the court should, generally speaking, hear evidence and determine factual disputes for itself. And yet, despite that fact, the process is still, as it was said in Runa Begum, was said to be Article 6 compliant, a matter that's been confirmed in Ali and UK in 2015. So points of law arising from the review decision, but not, generally speaking, hearing live evidence and not there to decide issues of fact. Those are matters for the local authority. Looking then as to what the court is doing, it is, of course, just like in a judicial review, is exercising its supervisory jurisdiction. What they're looking at is effectively deciding, obviously being led by the grounds, as we'll see, has the authority's review decision or a Section 184 decision, if there hasn't been a review decision, involved a public law error? It's not enough to disagree with it, not enough to think it's a bit harsh. Has there been a public law error? Did they make sufficient inquiries? Did they make a finding upon which there was a rational basis, or whatever? And does that error vitiate the authority's decision? There may be faults in process, there may be faults in reasoning, which actually have no binding effect or impact on the decisions to be decided, and therefore aren't a proper challenge. And what we know, and there's been cases like Rother District Council and Freeman Roach in 2018, that the burden of proof lies with the appellant. Again, not a matter of dispute, it's quite clear, and it's the same as in a judicial review, of course. The burden of proof in a judicial review will lie with the claimant to show that there has been that public law error and that a remedy is appropriate in the form that they seek, whether that's variation or discharge of the review decision. But and this is quite an important point, the parameters of the appeal are defined by the grounds of appeal and set the agenda. And I would slightly widen that to say that the review decision is crucial to what Dean and I are talking about today. And the review officer looking at this is also defined by the representations made towards that review. And we'll see that in a little bit. But equally, of course, you're entitled as a respondent authority to be led by the grounds of appeal. You're not therefore having an open season on the review decision and looking at it, if you were for the applicant, thinking, well, that's also a bit dodgy and that's not really very good. You're entitled to say, unless you've amended your grounds of appeal, no, you haven't appealed on that basis. This is what we are looking at, and this is the basis of that ground of appeal. And as has been said, the role of the authority is effectively to demonstrate the review decision, although the burden of proof is on the appellant, but it's to demonstrate the review decision does not involve what has been said to be the public law error. And if it is, to demonstrate that it doesn't have the impact that is claimed by the applicant, such as to vitiate the bona fides of the ultimate decision. So that's effectively the 204 decision. There are, as I said earlier, limitation decisions. And as I say, I think, and I say this generally in litigation, I think one can be reasonably relaxed about these things. And I'm not the kind of person who believes in fighting for fighting's sake. If it's seen to be sensible to allow a slightly late appeal, do so. But in strict terms, as I say, you have to have good reasons. And Al-Ahmed was a case, for example, where the High Court had rather indicated that an individual without legal representation, and I'm paraphrasing now, of course, badly, but what they could do is they could fill out the appellant's notice and grounds of appeal themselves before legal aid had been obtained and proper legal advice had been granted. And the Court of Appeal didn't like that approach and thought that obviously as long as matters have been dealt with efficiently, a factor such as a delay in getting legal aid and therefore getting good independent housing advice may well, and I say may because it's a fact-specific issue, but may well constitute a good reason for a late appeal. Obviously, you need to ensure that there are points of law that arise from the decision, so you don't have, as in Dean's case of Adesotu, the discrimination claim, which can be knocked out if it is, but also that if it is, for example, like a contracting out, that is a perfectly valid ground of appeal, albeit, of course, on the facts, it may not really be effective. And if the grounds of appeal have merit, then, of course, what is actually being claimed? I mean, if, of course, you actually have somebody who's merely seeking a quashing of the decision, which is, as I said earlier, is the usual order, that may be legitimate. But if, of course, if they're seeking a variation, you might say, look, we're happy to quash and look again, but we're not happy to vary because it's not one of those cases where it is definitely going to be the case that the applicant is going to be not intentionally homeless or priority need or in suitable accommodation or whatever. And of course, the agenda is very much keeping the court to the grounds of appeal and the issues to be decided. As I say, there is sometimes a tendency to have a more discursive approach and look at the particular circumstances, and maybe very difficult, genuine circumstances of the applicant, where, of course, you're dealing with an appeal in a court and therefore really ought to be focusing very much on what the grounds of appeal are and whether there has been a public law error such as to justify the relief sought. And it's therefore also the case, of course, that witness evidence is going to be very limited. You know, one of the things that Dean and I have talked about is the standard directions that now come out from most courts. There's probably nothing greatly wrong with allowing variation once the housing file has been seen, rather than what they should be doing, which is seeking an application for permission to amend. But there is a concern as to encouraging witness statements, which, as most of us know from Ermakov, should only be used very, very sparingly. And that's probably not enough variance. And therefore, one's got to be careful, even if the direction allows a witness statement, it may still not be admissible and the local authority may still be entitled to say, fascinating though that is, none of that was before me as a review officer at the decision. So that's my section for now. And I'm moving on to Dean's, which is dealing with the question of prevention is better than cure.
Andy, thank you very much. That was, I'm sure you will agree, a very helpful roundup of the context, nature, and as I say, the type of appeal which one is faced in the Section 204 context. I'm going to move on, as Andy said, to the, I hope, forgivably trite proposition that prevention is better than cure. The reason that we have a section on this is because, of course, the prospects of successfully opposing any statutory appeal under Section 204 will generally only ever be as good as the review decision itself. Hence the point made on the slide that therefore the appropriate resourcing and the effective making of review decisions is absolutely essential. It brings to mind the old adage, shortcuts make for long journeys, and that may apply financially as well as in any other way. So what I'm going to do is look at, as indicated at the start, some of the common errors that Andy and I see in local authority review decisions. As I say, that may be a little uncharitable to phrase it in that way. Some of them will be common challenges that we often see, and the way in which they can either be prevented or dealt with in the context of a Section 204 appeal. So some of these slides will deal to a degree with prevention and some to a degree with cure. As for the first of those, deficiencies, irregularities, and the minded to letter. Now, where a review officer finds that there is a deficiency or an irregularity in the original decision, but is nonetheless minded to uphold the decision itself, then Regulation 7 of the Homelessness Review Procedure, etc., Regulations 2018, imposes an obligation on the local housing authority to inform the applicant and give him or her an opportunity to make representations. And that, of course, is a procedural safeguard which is enacted to ensure that there is fairness in the application process. The failure to provide that safeguard, or I should say the alleged failure to provide that safeguard, is, however, an error that is commonly encountered in Section 204 appeals. Why is that? Well, at least part of the reason, perhaps the main part of that reason, is that the concepts of deficiency and irregularity under statute are very widely construed and interpreted. And for that definition and interpretation, we need to look at the case of Hall and Wandsworth London Borough Council. It's the judgment of Lord Justice Carnwath at paragraphs 27 to 29. So a deficiency is essentially something that is lacking in the original decision, and that will not necessarily be limited to failings which would, in the context of the later appeal, amount to a ground of appeal, but something which is sufficiently important to warrant the invocation of this procedural safeguard, and important to the fairness of the process to require a minded to letter. And an example of that might be, for example, where the review officer identifies that maybe an important authority was not considered by the original decision maker, and the omission of that from the original decision would be something lacking. What about irregularity? Well, irregularity is something which is lacking in the manner in which the original decision was made. So in essentially a procedural irregularity or flaw or error. And that might include, for example, we can easily think of several examples, but a failure to consider a relevant consideration that was on the papers in front of the original decision maker. So, as I say, because those concepts are so widely construed, the obligation to send out a minded to letter in order to give an applicant an opportunity to comment on the deficiency, on the irregularity, and most importantly, on the review officer's decision to uphold the original decision nonetheless, is quite easily triggered. So I think the top tip that Andy and I can give you today is that if you are in any doubt as to whether something in the original decision constitutes a deficiency or an irregularity, send out a minded to letter. Now, increasingly, what we see is that this is a common feature of review officer practice, and it is a very sensible, if I might say, safeguard for the local authority, because even if the original decision does not incorporate a deficiency or irregularity, it nonetheless provides the local authority with the opportunity to say, well, the applicant's been given ample chance to make representations and to put forward his or her case before the authority. And that may play an important part subsequently in a 204 appeal when arguing before the court that, for example, despite a meritorious ground of appeal, that relief should be refused nonetheless. However, do keep an eye on limitation, that is the time limit for notifying the applicant of the review decision. There are now various different time limits because of the enactment of the prevention duty, for example. But just keep an eye on those, otherwise the statutory appeal will lie against the original decision as opposed to the review decision itself. So that's deficiencies and irregularities. We move on now to sufficiency of inquiries. And as I said at the start, these slides are intended to address more the way in which allegations of insufficient inquiries should be dealt with in the context of a 204 appeal. So it's not so much prevention as cure. Now, the duty under statutes that arises under section 184(1) is that an authority with reason to believe that an applicant may be homeless has a duty to make such inquiries as are necessary, and I'll come back to that in a moment, to satisfy itself whether the applicant is eligible for assistance, and if so, what duty is owed to them. Now, as I say, the alleged insufficiency of inquiries is commonly a ground of appeal in Section 204 proceedings. And the way in which that is often effectively dealt with is by emphasising the considerable leeway and protection that local housing authorities are afforded when it comes to deciding the appropriate scope of those inquiries. And that's not least because the duty is to make necessary inquiries, and I refer back to the point at the top of the slide, not, and I stress, not all possible inquiries. And that's a point that was reinforced very recently in the case of Insufficiency, which is cited at the bottom of this slide. So there is long established authority for this proposition. So what inquiries are considered necessary in the case of Bayani, including their scope and scale, was held to be a matter for the authority and not for the court itself. And indeed, picking up on the point that the duty is to make necessary inquiries and not all possible inquiries, an authority which has made inquiries can only be attacked for failing to make more if it has failed to make an inquiry which no reasonable authority could have failed to regard as necessary. And for authority for that proposition, we need look no further than Costello. Reinforcing that point, in Cramp and Hastings, to which Andy has already referred, the court should be wary of imposing on the review officer a duty to inquire into matters that were not raised by the applicant, a point that was reinforced and repeated in Insufficiency. So if an applicant has not raised an issue with the local authority, then very rarely will it be possible to criticise the local housing authority for failing to make inquiries about it. There is, however, a caveat to that general proposition, and that arises in particular where, for example, the public sector equality duty under Section 149 of the Equality Act 2010 might be engaged, for example, because the applicant might be disabled. In those circumstances, the local housing authority will have a duty to inquire about the nature, extent and effect of the disability, for example, even if the applicant doesn't specifically raise it. And it will need to do so in order to ensure that it, for example, complies with the public sector equality duty and its other obligations under the 2010 Act. So bear that important caveat in mind. The points that I've just made, bear with me one moment, derive not just from authorities under the 1996 Act, but in part from, and indeed are echoed in other public law contexts, not least immigration. And so we've set out on this slide a quotation from a fairly recent authority in the immigration context, that is H.L.R and the judgment of Lord Justice Underhill. I won't read it out for you because it reiterates some of the very points that we've just been considering. As I said at the start of these slides, despite all of that leeway, despite all of that protection that is given to local housing authorities, we do still see failures to make inquiries, and we certainly see a lot of grounds of appeal which allege an insufficiency of inquiries. And I have to say that I'm sure I speak for both Andy and I when we say we have a considerable degree of sympathy for the review officer because they perform an invidious task in dealing with very complex issues. And any oversight that actually occurs or is alleged to have occurred in those cases arises because of, no doubt, pressure on their time and resources available to them. And so perhaps a simple safeguard in such cases is when looking over the review decision before sending it out finally, simply to ask yourself, I've made these findings of fact, can it reasonably be said that I was entitled to make those findings without needing to make further inquiry? And that's a very broad question, I appreciate, and it has to be said that there comes a point in time when, even if there is a possibility that a further inquiry might help, the review officer is entitled to draw a line and say, well, I have made inquiries, I have enough information before me now. It's possible that further inquiries will result in further information, but I have enough to make this decision. And at that point, they are entitled to draw the line and say, actually, no, I'm not required to make all possible inquiries, just those that are necessary. So hopefully there we've given you some authorities that will enable you to deal effectively with any challenges that are brought on the basis of inquiries. As for common issues in the treatment of medical evidence, the principal point that I would really emphasize is that which is set out at the very top of this slide. And that is that an authority is, and you may think it trite for us to say this, is entitled to obtain its own expert evidence in order to assess and deal with the extent, the nature of, and the effect of medical issues that are alleged by the applicant. And for example, we only need look at Hall and Wandsworth, which is cited in the previous slides, for authority for that proposition. But critically and importantly, issues such as vulnerability, issues such as suitability are to be determined and must be determined by the authority decision maker, not by simply rubber stamping the opinion of the local authority's own expert. So importantly, the review officer will therefore need to carefully explain his or her reasons for a negative decision, and also his or her reasons for preferring one opinion of a medical advisor over that of another. So remember, you cannot simply rubber stamp the opinion really of any medical expert. You as the local authority, as the review officer, must explain why, in your view, such and such evidence is to be preferred over, for example, any presented by the applicant. Which brings me on to the next point, that of course applicants do frequently present their own medical evidence in support of their challenge to a homelessness decision. And that, of course, must be given proper consideration and regards. Osmani and Camden, London Borough Council, tells us so. But also importantly, if necessary, questions can be put to that expert, to that medical advisor, either to clarify any opinion that has been expressed, or indeed to challenge it in light of subsequent evidence that the local authority has obtained. So it is perfectly feasible, and indeed in many cases advisable, to go back to the applicant's advisor and say, well, look, you know, here we have an opinion which directly contradicts yours. Before we make a decision, we'd be interested in hearing your view as to why you say, for example, yours is the more credible opinion. And then you as the review officer can take that into consideration. Where there is such a conflict in the medical evidence, then the review officer must, when determining which evidence to prefer, consider issues such as the qualifications of the medical experts and whether or not their opinions are based on an assessment in person, an examination of the applicant. I'd encourage you to look at the case of Bishop as authority for that proposition. Where, for example, there is competing medical evidence and the review officer is minded to prefer that of the local authority whose advisor has not seen the applicant or necessarily considered the entirety of their medical notes, then I would suggest the local authority, the officer, is going to have to present fairly cogent reasons for preferring its evidence over that of the applicant, and will need to explain its case much more carefully, for example, than if their advisor or expert had actually assessed the applicant in person. A salutary note about the treatment of and the weight to be attached to local authority medical advisors, and Andy and I frequently see local authorities using the likes of Now Medical to seek advice about medical issues. Have a careful read of H.L.R and Birmingham City Council, in which it was held that housing officers should not be expected to make their own critical evaluation of medical evidence, not least, of course, because rarely are review officers actually qualified to do so. They should therefore have access to specialist advice. But the function of the authority's medical advisor is generally to enable the review officer to understand the medical issues in the case and evaluate them for themselves, and indeed to evaluate any expert evidence that is advanced by the applicant. But going back to the point that I made just a moment ago, absent an examination of the patient, that medical advisor's evidence cannot itself ordinarily constitute expert evidence. Which brings me back to the proposition, to the point I made earlier, that where, for example, you have a medical advisor who has not seen the applicant, and by contrast, you have an applicant's consultant, for example, who's been treating them for many years, you're going to have very cogent reasons, I think, for preferring the medical advisor's evidence over that of the more qualified expert who's seen the applicant. Moving on then from the treatment of medical evidence, this is I have to say, when Andy and I were discussing this, if you like, a particular bugbear of mine and Andy's, which is the tendency to overcomplicate the review decision and make particularly lengthy representations in it. Lengthy, repetitious, and if I can put it this way, overly legalistic review decisions, as indicated on the slide, are often written not so much for the applicant, but for the solicitors representing him or her, not least because, of course, it's the solicitors who put forward various challenges, including legal challenges, to the way in which the original decision is made. But they frequently, in doing so, go far further than the duty to give reasons requires. And summarizing very broadly that obligation, which was explained in the case of Graham, it is a duty to give such reasons as are sufficient to enable the applicant to understand why a decision has been made against them, and to assess whether they have any realistic prospect of challenging that decision. And it goes no further than that. It's certainly not an obligation to provide the applicant or his or her solicitors with a treatise on the law that is relevant to a particular issue, although I will come back to this in a moment when dealing with the framework for making a review decision. On which note, that point is dealt with in the last section of this slide, headed Complicated Decision, Simple Structure. And trite though it may seem, this is what we would suggest as a very basic, simple way of structuring the treatment of any particular issue and the making of the decision. So identify the relevant issues at the beginning of the decision. What are the issues that the officer has to decide? Isolate them and address them each individually. And in doing so, identify the law, the guidance, and, for example, where necessary, the case law that is applicable to each. But do avoid providing a treatise on the law, because in doing so, it's not uncommon for local authorities to come unstuck. Having done so, identify where necessary what the material facts are, and where there is a dispute as to the facts, determine them, giving reasons for why you prefer one version of events as opposed to the other. And then give reasons, sufficient reasons for the resulting decision, so that the applicant can understand why you have decided in a particular way. But critically, and this I may put as a plea on behalf of me and Andy, please do not return to the issue again, save perhaps to summarize the decision and its constituent parts at the end. What we frequently see in some review decisions is a tendency to deal with an issue in one place and then attempt to deal with it again later on in the decision in one or more other places. And the consequence of that is that there is a far greater scope for inconsistency in the decision making and for error. So please avoid doing that. Isolate the issues, deal with them individually, and then make your decision, only returning to them in order to summarize what your decision is at the end. And hopefully that will give you a very basic structure by which to create and give an effective review decision. That is the last of my slides on prevention is better than cure. So handing over then to Andy, who's going to deal with the mitigation of risk once an appeal has been issued.
Thank you very much, Dean. Prevention is better than cure is obviously very sound advice, and obviously the matters that Dean dealt with clearly we would recommend be followed, and indeed in many cases already is being done. But of course the reality is that even good decisions are challenged. There's no restriction on review rights. quite properly. Of course, anyone's entitled to have a review of a 184 decision. And equally, there's no, as I said earlier, permission required to appeal to the county court. So even if it is a good decision, nothing to stop somebody appealing that to the county court. So if it fails, and we'll see this from the next slide, there are a number of things you can try, and indeed I'm sure for many of you are already doing this. One of them, of course, is early merits reviews. It's very easy to get too wrapped up with the appeal process. Once you get the M161, you probably haven't had much in the way of pre-appeal representations, and to be fair to the applicants, they've only got 21 days to appeal, so they haven't got much of a time to go through pre-action process, and therefore it's always useful, whilst dealing with the appeal and dealing with the processes that need to be undertaken for that appeal, to have a look at the decision and to decide whether in fact it's one that can be defended, as it were, on appeal, or whether it's one where the grounds of appeal do demonstrate a very good case where there has been a problem with the decision, such as it is likely to be quashed. In those cases, of course, it's best to settle early. I mean, there is reference there to Part 36, and as most of you will know, Part 36, of course, is there to allow parties to provide offers to settle and allow people to have protection. I think the reality is in homelessness, where it's only going to be used and be useful is in cases where you're offering to quash the decision if you're a local authority, and the applicant is insisting upon a variation of the decision. I think otherwise Part 36 isn't really going to come into the equation. The appellants themselves, of course, insofar as they're legally aided, their solicitors will have the obligation to the legal aid agency to contact the LAA, of course, if circumstances change, or if there's concern about the merits of an appeal. But in reality, what this slide is effectively saying is that, of course, once the appeal process starts, it's a good opportunity to have a look. I'm not talking about detailed advices, but just to have a look and see whether the grounds make out the case. The one thing I would say before moving on to the next slide is that in the back of your mind, always realize, of course, that in most instances, the applicant is going to appeal come what may. Even if you quash the decision and carried out a fresh review, if it came out as negative, there's likely to be another appeal. So it's not likely to avoid an appeal process if you are happy ultimately with your conclusion. And therefore, we'll bear that in mind if you feel that you've got a decent decision, and try to avoid thinking that, well, if I agree to quash it and then carry out a fresh review, that will save legal costs, because you're just deferring legal costs for the next time when they'll appeal. So mitigation is certainly a good idea. Options for dealing with it going forward, well, it says there, don't be the ostrich respondent. Clearly, as we say, if you look at it early, it's going to save time and money. Plus the fact, of course, if you look at things early, you've got a chance of arguing over costs. If you say to somebody before it's gone very far down the line, maybe we've got the directions from the court, the standard directions that most courts will hand out. If at that stage you say, look, we're prepared to cross the decision on a no order for cost basis, it does, let's be frank, put some pressure on the applicant, because unless it's a really dreadful decision, they can't guarantee that they're going to be successful on appeal, and you've got a much greater chance cost-wise of agreeing such a matter. As we'll see later, that's a more difficult thing if you wait until, of course, post-decision to argue about costs. But at this stage, you may have an issue which you are able to deal with. In terms of the early referral to counsel, that's not just a cry for work, because in many instances, and certainly in my experience, and I know Dean's experienced, we have a lot of respect and regard for the review officers we deal with, who know their work backwards and are doing generally a really impressive job. And equally, the local authority solicitors we deal with are similarly well informed. But again, it's always worth keeping an eye on things and seeing if, in fact, there is merit in something. Sometimes it's best to get it tested in the court, because, as I say, otherwise it'll only come back to the court if it doesn't go the applicant's way on a second review process. But the key questions are, does the authority's review decision involve a public law error, in brackets, on the basis of the grounds of appeal? And secondly, if it does, is that going to be sufficient to justify a quashing of the decision, or indeed even a variation, if the outcome is inevitable? So those are the two key questions. In terms of settlement options, it's limited, obviously. Clearly, as I say, if you have questions of remedy, such as a variation or a quashing, one can obviously decide and agree a quashing rather than the variation is a possible remedy. And of course, in relation to cost, as I've indicated earlier, one may have an argument over cost as to whether, in fact, no order for cost is appropriate if you agree to carry out a fresh review early on in the appeal process. You may also, of course, be able to, although I have to say I haven't seen this happen very often, in fact, that means at all, encourage your opponent to drop some grounds of appeal on the basis they're not arguable and they completely miss the point. It may be that they decide not to really push on certain grounds of appeal, but in terms of wasting too much time and money on reducing grounds of appeal from 4 to 3 or from 3 to 2, I don't think that's really a particularly interesting area for most people concerned in this work. The benefits, of course, of dealing with these matters as early as possible is if there is a genuine error, you're not wasting money on an appeal where you might get home on 2 or 3 grounds. You might get a good finding on 2 or 3 grounds, but you're going to lose, for example, on the fact that you didn't carry out a Regulation 7 procedure and you didn't do a minded to letter. So however good the rest of it is, it's something that you really have to consider. So it's not a question of saying, well, we're good on 2 grounds, but we're not so good on 3. If you're bad on one of the grounds and you're likely to lose on one of the grounds, and it's likely to lead to a quashing of the decision, concede and try and argue costs. And obviously, the Part 36 procedure, as I say, is particularly there where they're seeking a variation of the order. But even if you didn't go through the Part 36 procedure, for whatever reason, maybe the time you actually make the offer, for example, you can do what they call a Calder Bank offer, which doesn't invoke the rules of Part 36, but is still an offer which the court can take into account. And I think we're then moving on to the rather interesting area of keeping a court happy, which is Dean's area. So over to you, Dean.
Yeah, thank you very much, Andy. Indeed, keeping the court happy. By the time we reach the court in a Section 204 appeal, there is only one person in that courtroom whose opinion and whose judgment matters, and that, of course, is the judge. And so keeping the judge in particular happy and making the judge's job as easy as possible is, you might think, critical to getting off on the right foot, the front foot. So don't start an appeal hearing on the back foot, as the slide says. Do the simple things right. Comply with court deadlines, or if you need to, apply for any extension of time, but before that deadline expires. Frequently, what we see is that being done by way of correspondence. Of course, that's not going to be sufficient. Where you seek an extension, you are going to have to put in an N244 formal application notice supported by any necessary evidence. And provided you do that before the deadline expires, and generally speaking, provided you can still accommodate the court's directions within any trial window, then it's likely you're going to get some favourable decision, or at least some sympathy from the court. In the same vein, keep the court office appraised of any matters that are likely to affect the listing of the case, and indeed time estimates. One particular issue that vexes many judges by the time a case actually gets into court is that they are presented with a bundle and with a number of grounds of appeal and opposition to them that simply do not lend themselves to a disposal within a day. And the complaint frequently made is, well, you know, this is a case in which the party should have been writing to the court to tell us that actually the time estimate was not going to be sufficient and that further time would be needed, or indeed, where the issues are narrow, that only half a day would be required. So in light of recent events, and not least of which, of course, COVID, the court places considerable emphasis on the parties cooperating proactively in order to ensure that court time is used effectively. if you can, and I know this is sometimes difficult for local authorities, attend any court user groups. I think they may have been fewer and further in between recently because of COVID, but they are nonetheless, when they occur, an important opportunity to meet either the judges and or the court staff who generally deal with these appeals, and to get a feel for the issues that are really vexing them at that time and how to resolve them. So they're an important venue in which the local authority's presence and indeed its views about the way in which these cases should be dealt with can and should properly be considered. And then perhaps most importantly, returning to the point at the very start, is keep the judge on side. And one of the most important ways of doing that is to ensure that the papers with which they are provided are functional and well organized and enable the judge to move quickly from relevant document to relevant document. So a carefully structured, indexed, paginated, and dare I say properly bound bundle, which is legible and limited to only those documents that are truly necessary to dispose of the appeal, that will go a long way. Don't do what one of my clients did, bless them, in a recent case, not a Section 204 appeal, which was to turn up to court with a bundle that was not just not bound, but not hole punched, didn't have a full index, and the pagination was also incomplete. Needless to say, they incurred some judicial disfavour at the start of that hearing. So a simple way to structure a bundle, statements of case right at the start, because they are the critical documents which shape the appeal and indeed, as Andy was saying, set the agenda for it, followed by any court orders and notices. Then it's probably worth putting in the review decision itself in its separate tab, because that will be frequently referred and returned to. Following that, key documents such as medical evidence or key correspondence to which the parties will need to respond again repeatedly. And then, and I would sound a note of caution when it comes to this point, the homelessness file, but redacted as far as you can, so that it only includes those documents that are really necessary to disposal of the appeal. Please don't just insert the entire file, because that is likely to be frowned upon by the court. And then following that, any relevant inter-parties correspondence that is not already included. That will give you a simple structure. If you paginate that, index it effectively and tab it, you will have the judge on side from the very start. I appreciate that the obligation to compile the bundle usually lies with the appellant in these cases, but that of course does not absolve the local authority from responsibility for at least seeking to provide the court with a properly structured and paginated bundle. Lastly, don't forget a statement of costs. Section 204 appeals are sometimes very difficult to win, but we certainly win quite a few of them. And if you want your costs in those situations, you must file a statement of costs, because generally they will be summarily assessed. And what you don't want to do is lose an opportunity to recover your costs, at least in principle, where that opportunity arises. And then secondly, just a note about skeleton arguments. Now, ordinarily, these will be a matter for counsel instructed in the Section 204 appeal, but a few pointers to ensure that that skeleton argument really fulfills its essential function. And that is that it's there to assist the court and to promote the local authority's position in response to the appeal. So generally speaking, keeping it in the same way that one edits the bundle to make sure that it contains only necessary documents, keeping it as brief as possible and dealing with only necessary points is key. Don't therefore oversight authorities or ensure that it doesn't oversight authorities. The judge will not thank you for that. Coming back to a point really that Andy's made on a couple of occasions, if the appellant makes a good point in the skeleton argument, don't be afraid to simply agree with it. You will, your argument and your position will be given far greater credibility and weight if the judge can see that you are taking a sensible view about the appellant's position. And of course, coming back right to the very start of our presentation, don't forget to stress the judicial review nature of the appeal, and that it's the appellant that bears the burden of satisfying the court of the public law error, and indeed that relief should be granted. and therefore there is a high hurdle for the appellant to cross. Coming back to the point of brevity, keep on point, address the appellant's arguments head on, don't make the mistake of avoiding the difficult arguments, deal with them. Avoid extreme language, because that's likely to marginalize the judge. Again, it comes back to taking a realistic view about the case and dealing with it appropriately. And of course, fundamentally, the skeleton argument's job is to persuade the court as to the local authority's position. So just make sure that any skeleton argument settled on your behalf does exactly that. And don't be afraid to come back to counsel, whether it be me or Andy or indeed anyone else you instruct, and say, look, I think we could perhaps deal with this in a more persuasive, in a more effective way, because certainly I know both Andy and I are open to constructive feedback about any document that we draft. Ultimately, it has to be a product that all of the litigation team is happy with. And so to that extent, it should be a collaborative effort. So a few key points, I hope, helpful points, with a view to keeping the court on side. Without further ado, therefore, handing over to Andy about mitigating risk and minimizing liabilities.
And we're dealing with the last section now, in the last 3 pages, I think, to go before we get to some questions. We've been having some fun in the chat function, answering various bits and pieces, but I'm just dealing with minimizing liabilities at the end. And as you can see there, there are situations where the court, even if a ground of appeal succeeds, will not give an order that the decision is quashed or varied. To give one example of that, I had a case a few years ago in central London where we succeeded on the substantive grounds in terms of, excuse me, in terms of a suitability challenge, but we hadn't set out which part of section 193 we were discharging our duty under. And although I told the judge which part it was, obviously I'm not entitled to give evidence, but he did accept the submission. There's no point sending it back because we succeeded on the substantive suitability grounds, only for us to give a letter in exactly the same form, but with the right provision of section 193 contained. It was a pointless exercise. In other words, we would inevitably reach the same conclusion. And I should also say, because I've just seen it flash up, it is an issue for the court, by the way, out of time appeals as to whether to agree an out of time appeal. But the reality is, in most instances, if the respondent agrees to the application to allow the appeal, for permission to allow the appeal out of time, the court will concur. But it is a court decision. Going back to the dealings I'm dealing with, of course, if you succeed on an appeal, if you're the applicant, you would normally get a quashing of the decision or a variation. But equally, there'll be situations where the appeal itself is an abusive process because it's pointless. And the reference there is to O'Connor and Kensington. It was a heavyweight contest in so many ways between Brian Maguire and Andrew Arden. And talking about the court's inherent power to refuse relief, and of course questions of whether the legal aid agency would refuse legal aid, and effectively saying that really that was the issue that would protect pointless appeals where perhaps situations had moved on. So, for example, you may have offered somebody property which they considered unsuitable, but in the meantime they had moved elsewhere into what was clearly suitable accommodation. What's the point of continuing with an appeal? And the point was made that the legal aid agency clearly wouldn't fund such an appeal, and that therefore it's unlikely there'd be many cases to do where it would actually happen that there was such a pointless appeal. And of course there'd be a cost penalty, because undoubtedly even if the appeal was allowed, it may not be that relief would be granted, and therefore cost may well be awarded to the local authority, and therefore there would be that risk. So it is a question. I mean, that was actually a case about the failure to consider good faith, but it is a question which doesn't arise very often. Normally you can understand why there's an appeal, even if you feel it's not a very good appeal. It's not normally so bad that you could really characterize it as an abusive process. And as it says there, and as we've already indicated, the court should only vary a review decision in rare occasions, in cases where, of course, there's no point sending it back because it's obvious that the person's in priority need. It's obvious that they're not intentionally homeless. It's obvious that the offer of the property was not suitable. It's obvious that they're eligible for assistance, or whatever the issue is. And there's no point wasting anyone's time, local authorities or the applicants or the courts, in try to encourage fresh review decisions and fresh appeals. And in those rare cases, the relief should be a variation of the decision. But as I say, I would guess in 90% plus of cases, what is being sought in reality, even if not as stated in the M161, is a quashing of the review decision. And moving on to the question of cost, this has come up in the chat function. And if I go straight to the second bullet point, reference has been made, I think by Johan, quite properly to M. Croydon. M. Croydon, of course, is used frequently, for those of us who do public law, is used frequently, and quite properly, of course, to rather suggest that, well, look, wait a minute, if I'm actually getting the relief because you've conceded and you're giving me the relief which I've asked for in the appeal, then why shouldn't I get my cost? I mean, that's a very broad summary as to how Lord Neuberger was looking at the matter. But why shouldn't I get my costs? So if you, the local authority, say, look, I'm happy to look at this decision again and carry out a fresh review, that's what I was seeking in the appeal. Why shouldn't I get my costs? The difficulty is, of course, if you're the applicant, is that if it's an offer that says, well, we're only going to quash it if you agree no order for costs, there is that risk that although you might say M. Croydon, there is the risk that, in fact, you may not succeed on the appeal if you're the applicant, and therefore there'll be no quashing at all. And the cost award probably isn't of any great relevance, but there is that risk. And I think it's something that has to be considered if you're an applicant solicitor, an applicant even without solicitors. Do you want the guarantee of a quashing with a no order for costs or not? Now, sometimes the way round it is they argue that what should go in there is an agreed that the appeal, the order be quashed, no order on the appeal, and submissions, written submissions on the questions of costs. And of course, the courts are very loath to get into satellite litigation on costs, and therefore they may well accept that kind of position. And I've certainly had to do written submissions on a few cases in the last couple of years. And so it does happen that way. But as I say, it is for the local authority quite a powerful tool early on, despite M. Croydon, to say, well, we're not going to agree to quash it unless you agree no order for costs, because we're quite confident, whether or not you are or not is another matter, but we're quite confident that we can defeat this appeal. And that's something that will be looked at. And of course, you've got to consider, well, what were you seeking? And so, for example, if you had a case where there was a question of, I don't know, priority need, and you had decided against the applicant, and said that they were not priority need, but after the review decision, there had been some very good medical evidence that had been submitted by the applicant or even by a third party that had got to the local authority where they thought, well, actually, we can now maybe see what you mean. It may well be that that's a good example where, in fact, yes, you are agreeing to the same remedy that they were seeking. That's a quashing of the decision, but for reasons that were unrelated to the appeal itself, but related to the late information that's been received by the applicant. So those are the kind of questions that you want to look at. Parveen, incidentally, is just a case that upheld the no order for costs that have been granted at the county court level. There is also, I ought to say, the possibility of percentage cost liability. I had a recent case, for example, where there were 3 grounds of appeal, including a contracting out ground, which was a successful ground. The other grounds on the question of priority need were not successful, and we agreed a 70% cost liability on a standard basis. There's always a possibility of arguing that, and if the other side won't agree, then of course, again, you can suggest written submissions if the parties can't agree the order, and that's perfectly okay to try. Johan has quite properly said in a note that just flashed up on me that, of course, you can't enforce cost orders against appellants without the court's permission. Well, of course, that's obviously true, because, of course, that's why you have Section 26 of the Legal Aid, Sentencing and Punishment of Offenders Act 2012. But 2 points to note. Some authorities don't do cost schedules because of that very point. that Johan has mentioned, but also sometimes it's always a good idea to have a costs pot, because you never know when you might need it to set off against a liability the local authority might become liable, maybe on a future appeal, for example, or a future situation where you can say, fair enough, we owe you X amount, but you still owe us Y amount from this appeal. So it's okay. The normal order, if the local authority would win, would be that the appeal be dismissed, and even if the party is legally aided, the appellant do pay the respondent's costs on a summary assessment basis, and then whatever your summary assessment is, to be subject to a determination of the appellant's ability to pay such costs pursuant to Section 26 of the Legal Aid Sentencing and Punishment of Offenders Act 2012. The mere fact I know that is sad, but that's what you have. And sometimes you'll even add, such assessment to be adjourned, generally with permission to restore, so as to move the 6-year limitation. But that really is very sad at that point. And then, of course, there'll be a detailed assessment of the appellant's legal aid costs for their benefit. Payments on account, you're getting these. For many years you didn't. In JRs, they've been happening for years, of course, because it's just part of the CPR. If you have a look at CPR 44.2, subparagraph 8, it makes it quite clear that the successful party is entitled to a payment on account. It's not a question of, should I give one? They're entitled to it. The difficulty, of course, is how much, and it's only happened in homelessness cases, in my experience, in the last 12 months. Somebody must have had a word. What tends to happen, and the word must have been, is that they've suggested that you pay us 50% of the costs within 28 days of the bill of costs. My response has always been, no, you come up with a figure now, because you must have a figure. The last time we did it, they came up with a figure of about 60,000, which I've seen in the comments section. Somebody beat me on that one to a 70,000, which I don't quite understand how that's possible. But anyway, we agreed a 10,000 payment on account, which was nearer what we were paying, of course, for our legal costs. But yes, certainly there's no point opposing payment on account. Your battle's going to be, if you've lost an appeal and they want their payments on account because there's a cost order in their favour, how much? And you're normally in a JR situation, you're normally looking at maybe 2/3 to 75% of costs, and therefore you're entitled to say, of course, well, what are your costs? Give us an idea. And if they're fairly modest, because most local authority costs are maybe around £10,000. If they're around 15, 20, you might say, well, okay, we'll pay the 10,000. But as I say, when you get to a claim that there may be 30, 40, 50, 60, 70,000, then of course you may want to query whether that's possible and whether that's fair to base the percentage assessment on such a high untested figure. And lastly, it's worth just pointing out the 3 cases that you may know, well, you obviously do know already, because you know about M and Croydon, which is the one that we all cite. It's the one that's in the Administrative Court Guide of 2022 and in every year. But just note, of course, there were the cases of Ursus and Redbridge, where it said that judge had been entitled to make an order of no order of costs when appeal under Section 204 had become academic and discontinued. Because, of course, what the court is not going to do is going to start doing a mini trial as what would have happened if the person had proceeded with the appeal. And therefore, no order for costs would be an appropriate order in such circumstances. In Unici and Southwark, and there may be people online who are more involved in that than I was, of course, because I wasn't involved in it at all, it said that an appellant who had withdrawn an appeal against a homelessness decision because the local authority had agreed to carry out a fresh review in light of a psychologist's report was entitled to a cost. And I think that's the point that Johan was making earlier. The local authority had been aware at the time of the first review that a future report might affect its decision, but has proceeded regardless. Now, that would seem to be perhaps related to a reasons challenge or an inquiries challenge, more than the reasons challenge probably, and saying that more evidence was required and was available and could be obtained, and that therefore the local authority should have made those inquiries. But that obviously confirmed, in a sense, the M and Croydon approach, is that if you get what you were seeking, in essence, you should be entitled to your costs. But as I stress, it doesn't stop the local authority making an offer to quash with no order for costs, and saying that if you don't accept that, we'll proceed to the appeal. And it's on that point that I think we now, Dean, we go to questions.
Yes, although I think we've probably overrun by about 10 minutes, so we might want to keep them minimal. But do
you want me to read out? I don't know if you've got access to the chat function.
I appear now to have access to
excellent.
it. So
Johan talks about local authorities should look to see if a wasted cost orders could be attained against solicitors. I have to say, I'm not saying it's impossible, of course, because it's always possible. In my experience, it will be quite rare that it would come on the radar, if I can put it that way. So I wouldn't say never, but of course, wasted costs in homelessness appeals are no different than wasted costs in any other litigation. And you would need to look at the particular facts. But it's a fair point, Johan, that it's there on one of the things to think about, but probably not going to be something that in most instances you're going to be seriously considering.
Yeah, and on the question of costs, can I just reinforce the point that Andy quite properly made and rightly made earlier about seeking local authority costs when you succeed in a 204 appeal? That really is important, and I would encourage you not to deprive yourself of that opportunity, not least because even in the context of Section 204 appeals, it's not wholly uncommon for the appellant to have a second bite of the cherry, for example, later on when further down the homelessness chain. And in those circumstances, if indeed they succeed, you would then be able to set off any cost order you receive in the first set of proceedings against the second. And it's conceivably it would even be possible to set off costs in your favour in a 204 appeal against costs for which you are liable in other proceedings brought by or involving the same applicant, even if perhaps in a different housing context. So it's probably an opportunity you don't want to forego. And just on that point, and there was a question about the particular form in which the statement of costs should appear. I think maybe someone has answered this. It's the N260.
Okay. Is there any other questions anyone has? Anyone good at typing quickly? If not, I think that probably wraps up. I mean, we're always looking to do webinars on subjects that are of interest and important to our clients. So please, if you have any ideas, please send them through to Chambers, and we will clearly try and respond to those and see what is relevant to people and what they would find useful. We've already done many at the moment. You'll see our webinars that have happened over the last couple of years, in fact, if not more. Certainly on our YouTube account, you'll see on Cornerstone Barristers YouTube account, you'll see them. This will be up on our YouTube account within 24 hours, in my experience, and it should be on our website as well with the slides as well. So if there are no further questions, can I just, I think on behalf of Dean and I, thank you so much for attending. I'm really grateful, really appreciate it, and wish you well for a lovely day and lovely time ahead. Thank you very much.